There is new building safety legislation, but what does it mean for developers, managing agents, and people like you and I who live in flats and apartments? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel and like this video. Jessica Stanway is a solicitor within JMW's property litigation department. So Jessica, as I mentioned, there is new legislation, the Building Safety Act. What is the Building Safety Act?
So the Building Safety Act was introduced last year in April, and it's designed to make provision about the safety of people sort of in or about buildings and to regulate the standard of buildings moving forwards. So when we're talking about the Act, it's important to understand the context in which the Act came about. It was effectively in response to the Grenfell Tower fire in 2017, in which sort of tragically 74 people died and many more were injured. And it raised serious questions about the fire safety of high-rise residential buildings. In Grenfell Tower, the spread of the fire was accelerated by dangerous combustible cladding, as well as other construction issues. And subsequent government testing of similar buildings revealed that many other buildings were likely to be affected by the same things. After that, the government commissioned this independent review of building regulations and fire safety, which was led by Dame Judith Hackett. And that examined the existing building and fire safety regulations and was intended to make recommendations to ensure that we had the sufficiently robust regulatory system for future construction, and so that residents wouldn't feel as though the buildings that they lived in were unsafe. The main findings of that report is that the current system wasn't fit for purpose and that a culture change in the industry was needed. And that leads us to the Building Safety Act.
And so we could probably talk about the Building Safety Act all day. What are the most important bits that people need to know about? So
it's a really large and sort of far-reaching piece of legislation. It's got huge implications for everybody involved in the property industry. It affects the design, planning, construction, occupation, and alteration of future buildings, the manufacture and marketing of construction products, as well as regulating sort of liability for historic defects. Obviously, a complete explanation of everything it includes is going to be beyond the scope of this video, but in terms of a few sort of key reforms and provisions, we've sort of got overall this new regulatory regime that's going to apply to the planning, construction, occupation of higher risk buildings, which is buildings over 18 meters. It also introduces this role of building safety regulator, who will have duties and functions in relation to reviewing and improving building safety standards. It introduces a gateway approach to the planning and construction process, making it mandatory to obtain building regulation approval for a project before it's constructed. It creates a role of duty holder, which actually captures lots of people in the process, right through from sort of those responsible for design, contractors, surveyors, things like that. And it assigns these definitive responsibilities to these roles. It's got significant impact on management of high-risk buildings as well, and it creates these sort of onerous obligations and will definitely impact the way in which managing agents work in these buildings moving forwards. It's got significant sanctions for non-compliance with these obligations and extends the scope as to who these sorts of claims can be brought against. So it's no longer just companies. You can go behind that and pursue individuals in some circumstances. There's changes to the law regarding the liability of developers in particular and construction product manufacturers for building safety defects, including those historic defects. And it implements these sort of tougher penalties for those that break the rules. It's creating all sorts of new causes of action in relation to construction products and makes significant extension to periods in which certain claims can be brought. And finally, and this is something which has featured quite heavily in the news, is how it addresses the issue of remediation works and in particular who pays for them. The Act is designed to create this waterfall effect, placing liability for the remediation of unsafe buildings with those who developed them. And it's designed to try and protect the occupants who would ordinarily pay for these works via a service charge from having to pay. you'll see Michael Gove in the news quite a lot, effectively threatening developers that if they don't comply and fix these buildings themselves, then they'll pay in other ways. But the Act itself, it's really only a framework. It will be supported by sort of secondary legislation and regulations in a number of areas. And it's these regulations which will contain more prescriptive guidance on how parties can meet their obligations under the Act. And it is important to just sort of note that at the time of this video, not all parts of the Act are in force. We are expecting that they will be by the end of this year. That's the commitment. And the provisions currently in force sort of focus mainly on the remediation of fire safety defects in affected buildings, but the scope is widening, and we fully expect that the Act will have a greater effect than was intended.
Jessica, thank you so much for your insight. If you'd like to contact Jessica and the property litigation team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.